Good afternoon, Council. I normally say we don't anticipate any technology-related problems, but apparently with the weather that Middle Tennessee is having right now, we might well anticipate some technology-related problems. But if we do have them, everybody just take a deep breath and we'll pause and work through it. We'll hear from the appellate now.
May it please the court. My name is Mary Beth Hagan, and I'm here on behalf of the appellants, Wilson Bank and Trust and KW Group, LLC. This case starts with a real estate development. Our predecessor in interest purchased property, and in order to subdivide the property for a neighborhood, the local utility district required that the developer deed over enough land for a step wastewater sewer system. And so that happened with the predecessor in interest. What went wrong is that the legal description in the deed included more land than was needed for the step sewer system. Everybody agrees to that. The construction drawings and the plat show part of this land as open space and HOA clubhouse space. All of that was mistakenly deeded to CUD in that warranty deed. And CUD has since taken the position that they cannot return what I will call the excess land unless the developer pays for it. So this case ensued, and in this case, the parties realized that there were a number of agreed upon facts. So the parties approached the judge at the time with a procedure to put forward the stipulated facts and see if the judge could make a ruling. From the appellate's standpoint, the issue was this idea from CUD that they had to receive consideration in order to transfer back the excess land that was mistakenly deeded. And you can see that from what the appellants filed first. But what they did was present it to the judge. Let's show you the stipulated facts. We will each submit a brief at the same time, and then we will each submit a response brief simultaneously as well. When the appellants filed their first brief, you could see it in the record. It focuses almost entirely on the statutory framework 782-309 that deals with CUD and its board conveying real property. And our goal was to try to overcome this idea that CUD had to be paid in order to return the excess land. We also filed at that time an affidavit of Mr. Knox, who was with the developer KW Group, LLC, and there was a motion to strike. By that point, there was another judge on the case, and we understand things happen. And certainly here in Rutherford County, we have had several cases where multiple judges have been on that file. This particular case had 5 different judges on the file. So when the third judge was over this case, that's when there was a motion to strike the affidavit. And the third judge interpreted the order that set out their framework in the same way that we did. And let me back up because I didn't address that. With the second judge, when we presented this idea to the judge, there was an agreed order dated November 2019. In that agreed order, it mentions the stipulated fact submission, it mentions the memorandum brief submission, and it mentions the response briefs that would be filed simultaneously. But it doesn't stop there, and that is the crux of the issue. In the November 2019 order, it says, should the court determine that additional information is necessary, the court will inform the parties of the same. So the appellants were proceeding under the idea that if the stipulated facts were insufficient to make a ruling, the court would come back and we would have an opportunity to present other facts that we had that could not be stipulated to. That was the second judge who entered that order. So fast forward, when the third judge was handling the case, that judge entered an order in, I believe it was March of 2020, and referenced the fact that 1, this was an atypical procedure, and 2, that he was reserving ruling on whether to strike the outside affidavit until the court reviewed to decide if additional facts were needed. It was ultimately the 5th judge on this file who entered an order. And that judge said no outside facts will be considered. And in the order that we are appealing today, which is from January 2021, that court found on each of the appellant's claims that there were insufficient facts. So there was a need for additional facts. Rather than coming.
Let me interrupt you there, Ms. Hagan, because I think the difficulty with the argument is the trial court's ultimate finding, in my opinion, is not that there were insufficient facts from which the trial court could reach a conclusion, but rather the evidence was insufficient for your client to establish its claim. And I think that's the distinction and the difference. How do you address that?
I would say that there was 4 different positions that the court addressed: breach of contract, which, and then unjust enrichment, promissory estoppel, and then the rescission and reformation. With the mutual mistake or the breach of contract, the court overlooked the warranty deed. That was the contract. And so the trial court found that there was no contract between the parties, overlooking that there's the warranty deed. It is the warranty deed in which contained the mistake. That is the agreement that we were asking to be reformed or rescinded.
And the trial court, did the trial court have that warranty deed, was aware of it?
Yes.
Yeah.
It is in the record. It is part of the stipulated facts, but the court was looking for some other contract. I'm not sure if it was looking for some sort of purchase contract, but there is no other contract. It is the deed, and that is never referenced by the trial judge, even though it's in the record that was before the trial judge. With respect to unjust enrichment, I will tell you, my argument is that the trial court flipped the legal standard for unjust enrichment. All of the analysis is what benefit did the plaintiff receive and appreciate? And that's not the legal standard for unjust enrichment. Unjust enrichment looks at what benefit the defendant, i.e. CUD, received and appreciated, and is it unjust for that party to retain the benefit? So the analysis for unjust enrichment is the primary one where the legal standard was, the wrong legal standard was used. With respect to promissory estoppel, in the court's January 2021 order, it was held that an essential element was affirmatively negated, but the element that is referenced is substantial detriment. And so it is not that there's not evidence. If the court found that, to your point, that there wasn't evidence to show substantial detriment, because of the way the agreed order in 2019 was worded, it was our expectation that the framework was the court would not rule against us, but would come back and say, oh, I can't rule based on the stipulated facts. And then the parties would have the opportunity to present other facts and to have a trial on the full factual framework. So why did the parties do this? I think it's because in their negotiations, the sticking point was this idea that CUD had to be paid before it could transfer the excess land back. And again, if you look at the appellant's first memorandum that was filed pursuant to the 2019 agreed order, that's what's focused on. That's what they're addressing. You'll see that CUD addressed all of the claims. So certainly everybody wasn't on the same page, but that's the problem with the way this was structured.
Well, but didn't the order say that if the trial court determined that additional facts were necessary, he'd let you know, or she would let you know?
Yes.
And you're saying that you all just anticipated that the trial court judge would say, I need additional facts?
Or would have facts to rule on our claims. But what the ultimate order said was there were insufficient facts.
For you to prove that proved your claim.
Right.
Okay. All right. Let me ask another question, and it may not be necessarily with the issues kind of before us on appeal, but neither of your clients ever paid anything for this property. Is that correct?
Wilson Bank and Trust loaned the money and then went and foreclosed on the property.
But the part of the foreclosure did not include lot 50. Lot 50 was not in the foreclosure. Is that correct?
That's correct. But our client,
So WB&T didn't pay anything at the foreclosure for lot 50.
correct.
And then they conveyed what they purchased at foreclosure to KW, correct?
That's right. Yes.
KW didn't pay anything for lot 50 because, so you're asking that this lot 50 be transferred to your clients, even though they never paid, neither one of them have paid anything for it?
The reason is because
First is your answer yes? Is the answer my question? Okay, now give us the reason.
I'm sorry, Your Honor.
That's okay.
Because when Wilson Bank and Trust took the deed for the property, they succeeded to the role of developer. And then when KW Group LLC took the property, they succeeded to the role of developer. The original developer conveyed this land, lots 50 and 52, to CUD for the purpose of the step system to serve the development. And so reformation also goes to persons in privity of contract. And so because we are successors in interest on the ownership of the development, that's why we're asking to be able to rescind, or I think reformation is probably the better recourse, because we know that the step sewer system is needed for the development. That's not disputed. It's just a matter of CUD received much more land than needed. Also, on the unjust enrichment claim, the party asking for unjust enrichment does not have to be the party that paid for it. And so we can show that that CUD received the benefit, appreciated the benefit, and it's unjust for them. As a successors in interest, the court could find that it's unjust for CUD to retain that benefit.
What did WB&T buy at the foreclosure? Bankruptcy foreclosure.
At the foreclosure, they bought the rest of the development. So Richmond's retreat.
The property.
Yes. Because WB&T had loaned the money for the property.
I understand. So they bought the real estate.
Yes. And then succeeded.
You're saying, and it's your position that buying the real estate puts them in the shoes of the developer.
Yes, through the covenants that are in place.
Okay. Sorry, your time's expired. You have your time for rebuttal. We'll hear from the appellee.
Yes, may it please the court. My name is Roger Hudson. I represent Consolidated Utility District in this matter. This case began with a complaint filed by the appellants and an answer filed by CUD. Mid-Cumberland has never appeared, having been foreclosed upon and apparently in bankruptcy. No written or oral discovery was ever taken in this case. Rather, counsel agreed upon a manner in which to submit the case to the court, as evidenced by that November 21, 2019 agreed order, which was approved by the court. Ms. Hagan was not involved in that. She became involved in the case later. The order was followed to the letter, beginning with the filing of the stipulated facts after weeks of back and forth between the parties to come up with those stipulated facts and stipulated exhibits, which are substantial. And the briefs were filed exactly as ordered by the court. Appellant then filed the affidavit by Mr. Knox, which the trial court found was in violation of the agreed order and contradicted the stipulated facts. The agreed order clearly states that the case will be determined based upon stipulated facts unless the court requested additional information. And we've had a chronicling of different judges for different reasons, retirements and whatever that were involved. But not one single one of those judges ever asked for any additional information. And in fact, Judge Atwood, the circuit judge who ruled in the matter, said specifically that she was prepared to rule on the submissions by the parties as agreed and approved by the court. And in fact, in the appellant's own motion to continue and set filed in the trial court, it stated that if the court believed it could properly decide the matter based solely on the stipulated facts, it would have leave to do so. Well, the court didn't need the appellant's permission to proceed in that manner because that is what was agreed on and put in an agreed order. However, it does show that the appellant knew full well that that was the way this case was going to be presented to the court, and the court had agreed to that. There is nothing novel about the trial court making a determination regarding a case based upon undisputed and stipulated facts and briefs, as I pointed out in my reply briefs at page 18 through 21. Oral stipulations are binding, and certainly where you have months, weeks, at least in months, preparing stipulation of facts, those are binding. Neither party had to handle the case in the manner that it did. And the trial court could have said, I'm not going to handle it in that manner. But we agreed to it. Counsel on both sides agreed to it. And we submitted in that manner, and the court signed an order to that effect. Appellant argues that the trial court needed more proof and cites to the court saying that it found insufficient evidence to support their claims. Well, as Judge Davis mentioned, that's simply the court saying you don't have the facts sufficient to support your claim. It doesn't say we're going to stop the matter, go call in new witnesses and let you put on new evidence. If that were the case, anytime a court tried a case, at the end when it found insufficient evidence, somebody could say, well, we need more evidence to come in and try to change your mind, Judge. That was not the way this was ever handled. Every case falls on the sufficiency or insufficiency of the proof. And the trial court making that statement simply means you didn't meet up to the level of proof. The appellants and the appellee, my client, had every opportunity to submit the stipulated facts it thought to present to the court. And it's clear in that order that you should do that, because only if the court asks for more information is there going to be any more information. Now, appellant argues that a promissory estoppel applied, apparently because of some meeting in March of 2014 where CUD talked to the folks at KW Group. But if you'll note, the alleged promise to transfer the property, number one, can't be done by anybody other than the board. And secondly, it wasn't until 4 months later that KW Group bought this property from Wilson Bank and Trust. There's no evidence that there was any check with CUD in between those 4 month period to see if they transferred these lots. And in fact, everybody knew that there didn't. There wasn't any contract to transfer the lots. There was no consideration to transfer the lots. Basically, Wilson Bank and Trust transferred the property that it bought at the foreclosure sale, which specifically excluded these 2 lots, and transferred them to KW Group, again, specifically excluding those 2 lots. The trial transcript did note that CUD could possibly discuss transferring it to these people who had paid not one dime for it, as the court mentioned. If Mid-Cumberland was standing here who had paid money for it, we may have a different situation altogether, but we don't. We have Wilson Bank and Trust who didn't pay a penny for it. Matter of fact, foreclosed on it and bought it in at $900,000 as is shown in the record, and then sold it to KW Group and put a loan on it for $955,000 plus a letter of credit, $150,000. Wilson Bank and Trust has never said that they suffered any loss in this. So we're down to KW Group, and KW Group is the one who has paid not one penny for this and knew what they were buying when they bought it. So they attempt to support this argument with an affidavit which the court found contradicted the stipulated facts, and in its submission in the first place violated the agreed order, which it did. They argue that, well, there should be a reformation because CUD, Mid-Cumberland, and Wilson Bank and Trust weren't aware of what should be transferred. Well, that's not the case. Mid-Cumberland and CUD authorized an engineering report to show what would be transferred and what was needed. But for some reason, Mid-Cumberland transferred this property to CUD. CUD didn't draw the deed. CUD had nothing to do with the preparation of it. And there's certainly no evidence that CUD committed any fraud to get more property than it was supposed to get. Mid-Cumberland simply conveyed it. They asked for privity. There was no contract between CUD and Mid-Cumberland, and certainly no contract between CUD and KW Group or CUD and Wilson Bank and Trust. So in short, what WBT did, or the bank, I'm sorry, was released its lien on the 2 lots. Mid-Cumberland transferred the 2 lots. The bank foreclosed on the property and sold it to KW Group. There is no evidence.
I'm sorry for interrupting. Can we talk for a minute about the unjust enrichment? Because I do think the trial court's order is a little wonky on this. The trial court, in the last paragraph of the order addressing the unjust enrichment, correctly cites the law, which discusses appreciation by the defendant of the benefit incurred and acceptance of such benefit under circumstances where it would be inequitable. But then the court says, the plaintiff, KW, is the one who appreciated the benefit, and the plaintiff is the one who accepted the benefit. And then the paragraph concludes by saying, through the acceptance of the deed and payment of the purchase price, defendant KW Group accepted the property. I mean, I think that the court applied it in reverse, as Ms. Hagan said, but I know that you've made an argument that regardless, if it had been applied correctly, it wouldn't apply, basically.
Correct, Your Honor.
Yeah.
The bottom line is, as I've cited in my brief, recovery in an action of unjust enrichment depends upon whether, by the receipt of the property in controversy, the defendant was unjustly enriched at the loss and expense of the plaintiffs. And in this case, even if you consider unjust enrichment to Consolidated Utility District, it wasn't at the cost or detriment of either of these plaintiffs. Again, Wilson Bank and Trust has never mentioned any loss by any of this and turned around and placed a lien right back on it. And KW Group wasn't even thought about at the time this was going on and has never paid a dime. So if you come up with an issue of say, well, it might be unjust enrichment CUD, the only way to quote remedy that is what is being wanted by the appellant. That is just to transfer it to KW Group, who's paid nothing for it. There were some other arguments made, such as a Scribner's error. We went several different places on this. That was never brought up before. It's not in the stipulated facts, and there's no evidence that the manner in which you address a Scribner's error was ever done or even suggested in this case. So finally, just to summarize, Your Honors, is Wilson Bank and Trust had no possessory interest in lots 50 and 52, never paid a penny for it, and they released what interest they had. They've never alleged any financial loss. KW Group did not buy these lots when it purchased the property on July 1, 2014, knowingly. It was clear. They were clearly excluded from the transfer, so they knew they weren't getting them. And they're complaining about way back in March, you told us you might do something. We're here in July. Nobody's ever checked, apparently, or if they should have, they knew and clearly was in their deed that they didn't get these lots. So I respectfully submit to the court that the trial court's decision should be upheld. Thank you. Unless you have any questions, Your Honors.
I hear none. Ms. Hagan, we'll hear from you in rebuttal.
Thank you, Your Honor. With respect to the unjust enrichment claim, in the Freeman Industry versus Eastman lawsuit, it says that the benefit doesn't have to come from the plaintiff. Wilson Bank and Trust and then KW Group stand in the place of developer of this property. The restrictive covenants for the development are a part of the stipulated facts. And the CUD received what's admittedly more than what it needed for the step sewer system. They only needed the land required for that wastewater treatment system. It's admitted that they received more than that. So that is a benefit that they appreciated. And because of that, the development cannot meet the subdivision requirements for the county. That you can find in the affidavit of Mr. Knox. So we're asking this court to overturn the unjust enrichment claim so that the correct legal standard could be found on that. I think this court could look at what's in the record and find in favor of the appellants on the unjust enrichment claim. With respect to we're not disputing that oral stipulations are inappropriate. I understand that they happen and I understand that they are binding. And we understand that the agreed order was entered into by everybody. The point is that it didn't end with submit the stipulated facts and submit the written briefs. It went on to say that there was this caveat that if there were additional facts necessary, the court would come back. In the court's January.
We talked about this, but that's not the exact language it said. Didn't it say that if the court determined?
Right. I guess what I'm saying, Your Honor, is that because this is de novo review, I would ask you to determine that was an incorrect determination by the trial court.
That the facts were sufficient for you to recover, for your client to recover?
No, that the determination that there were insufficient facts and not to go back to the parties.
Let me ask you this, counsel. what was the point of submitting this on stipulated facts? If these were just stipulated facts that were to be part of a trial? Because as I understand your argument, if the trial court finds you didn't meet your burden to prove your claims, you say, okay, we get to present additional facts. And I guess the converse would be is if the defendant loses, the defendant would be free to say, oh, now we want to submit additional facts. Is that right?
I think that it certainly leaves that question open. I was not trial counsel.
I understand.
What I've determined in looking at the record is that there was a sticking point on the issue about CUD's authority to transfer back the property without receiving consideration. And you could see that that's where the appellate's head was, because that's what their first brief focused on. That's the only thing I can understand is the parties said, here are the stipulated facts, and the appellants were hoping the court could decide that issue, and then they could proceed from there.
Thank you, counsel. The court's thanks to counsel for both sides. We appreciate your oral arguments today and your briefs, and we're glad that we had no technology-related problems once we got started. So if you would please, Madam Clerk, please recess court till our next scheduled case.
This honorable court is in recess until 3 p.m.
Thank you.